Well, jury selection starts Monday for the surviving suspect in the Boston Marathon bombings. It was 2 years ago this April that 2 homemade bombs exploded near the finish line, killing 3 people and injuring 260 others. Dzhokhar Tsarnaev, he was arrested after a days-long manhunt that gripped the nation, and now the judge denying his lawyer's request to move his trial out of Boston. Robert Bianchi, he's a criminal defense attorney and a former prosecutor. Thank you so much for joining us, and Happy New Year to you.
Happy New Year to you.
So, not a very good gift to begin the new year for the defense in this case, because they wanted this case moved. Would that have benefited them, do you think?
Well, they may have thought that it would benefit them, but I don't see how it's going to. Their argument is that there's so much publicity in Boston that their clients wouldn't get a fair trial. But there's national publicity
everywhere.
With regard to this case everywhere.
Yeah.
And that's probably going to be part of what the judge's ruling is here. The courts don't want to move cases outside of the jurisdictions. They want to use the voir dire process, or the process of questioning jurors, to make sure they can remove any kind of prejudice, bias, or taint. And they can certainly do that in Boston. You don't need to move that trial anywhere else.
How do you do that?
Well, it's through certain questionings. The judge will ask the defense attorneys, what questions do you want me to ask? The prosecutors, what questions you want me to ask? It may be a difficult process. I've done this myself in very high-profile murder cases. And you have to have a very specific form. You ask them questions, and you interview and voir dire each individual juror in order to ensure you're getting people that won't be prejudiced and biased, even if they heard about the case, that they will do it based on the evidence, not based on the court of public opinion. It can be done. How
long do you estimate that that would take in a case like this?
I think it's going to take a significant period of time. Yeah. I actually had a case where a priest was murdered, and it was a very high-profile national case, and that voir dire alone and the questioning took months to get through them. Now, it all depends on how the judge handles it, what the issues are that the defense and the prosecution want to talk to those jurors about. But I think in a case of this nature, it's going to take some time here.
And what is your perception of the judge so far with his decision on keeping the case there?
I think he's made a good decision. We don't have the rationale to it yet. He said he would give us that decision. I wasn't surprised by this. I was surprised, however, that the defense attorneys have moved to try to appeal this decision at this point in time. It's a very unusual strategic decision for a defense attorney, because you'd rather have all of your motions denied and then at the end of the trial try to argue that that should result in a reversal should there be a conviction. So to do this now, tactically, in my opinion, is very bad, because if appellate court says, no, the venue needs to be changed, the defense lost a major argument on appeal. So
what possible benefit could they be seeing in appealing it now?
I don't think that they see a benefit other than, to me, maybe delay. They may need some time. I just don't know why. As a defense attorney, I do homicide work, I do defense work. I would never appeal a decision of this nature. I'd kind of keep it in my back pocket so that if there was a conviction for my client, I had the opportunity to say, Judge, to the appellate division, this decision from the court and other decisions caused an overall inability to be able to properly have a fair trial. I had this happen to me on a death penalty case I tried as an assistant prosecutor, not the county prosecutor, but the assistant prosecutor, and they made a decision to go to the appellate division. And the appellate division, in fact, said the trial judge was wrong in allowing the prosecution to admit certain evidence. And because of that, they lost a great appellate argument.
And you mentioned that that was a death penalty case. Yes. Talk to us finally about, the significance of the death penalty and guilt.
Yeah, sure. That's a great question, Heather. What happens is, in the case of this magnitude, the jury is first going to determine whether there's guilt, whether in fact there was a murder, whether it was a purposeful and a knowing murder. After, if they come up with that guilty conviction, and of course there's very powerful evidence in this case that they probably will, the jury then goes into the sentencing phase. Should it be a life sentence or should it be a death penalty sentence? The reason the court split it is because the evidence is different in the guilt phase versus the penalty phase. And it is in the penalty phase that you're going to see a lot of what's been written in these briefs, where they're going to talk about that he was under the control of his brother, and that he didn't have the opportunity to really make a decision. But that's going to be a really hard road in this case, because you have these guys making these devices. It was planned. There was preparation. They were in separate locations. So all of these facts, and of course he fled afterwards. All of this, the jury is going to be able to assess in the penalty phase to say this wasn't a person that was under some Svengali control. He was an active participant.
I was going to say he knew enough to run away in the end and drive over his own brother and hide in a boat in the back of somebody's yard.
Absolutely.
Okay. Thank you so much for joining us. We appreciate it.
My pleasure.
As always, we'll see what happens. And